Now let us delve deeper into the closing statements of the prosecution and common legal representatives of the victims. We have with us international law expert and University of St. La Salle Bacolod College of Law, Dean Ralph Sarmiento. Good evening, Dean. Thank you very much for joining us.
Yes, good evening po.
All right, let's start.
But clarify ko lang po,
Yeah.
hindi lang po ako Dean. I'm Vice Chancellor for administration ng university. There's a new Dean right now. Yeah.
All right.
But I'm still connected with the law school.
Thank you for that clarification, Attorney. And of course, ang daming nangyayari, but let's unpack so far what's happening today. What is your assessment of how both sides, prosecution and defense, are performing ngayon na it's towards the end already?
Well, actually, as expected naman po yung mga presentation nila, all the arguments and the defenses that we were expecting to be presented na present po nila. And I think both sides actually did well insofar as performing their respective duties, no, on the part of the prosecution. I think they were able to present a strong position. Not perfect, but strong one on the part of the defense. I also like the effort and the way matters were handled by Nicholas Kaufman. Also not perfect, but at least it was also a very good presentation. So ultimately depende lang po. I'm sure yung judges, tatlong judges po dito will be having a hard time, determining kung ano gagawin nila sa kasong ito.
Alright, Attorney, kasi ito, well, of course, yung mga hindi nakakaalam masyado nangyayari sa how the ICC looks at or conducts cases as compared to Philippine courts. Ang tanong dito is, with regards to witnesses or appreciating witnesses, sinasabi ni Kaufman, na why are we giving credence or weight to the witnesses right now who most are drug lords, drug peddlers, as compared to Duterte, who is merely just an accused at this point?
Well, yung ultimately po yung credibility ng individual credibility ng mga witnesses will have to be evaluated po talaga in a full-blown trial. At this particular stage of the proceedings na confirmation of charges pa lang, normally wala pa po talagang general credibility pa lang po yung tinitingnan, no?
Okay.
Kasi when you say credibility, is there a question of bias? Is there a question na yung propensity for the witness to lie, no? Mga ganon. Hindi mo pa po matetest yun during the confirmation of charges. So yung tinitingnan pa lang po dito as a whole, was the prosecution able to meet the threshold na reasonable grounds to believe na the crimes were committed. So medyo mababang threshold po yun. Hindi pa po ito proof beyond reasonable doubt yung hinahanap at this particular stage.
That's what I want to ask you, Attorney. Ano yung threshold with regards to a crimes against humanity case? Kasi sabi ni Attorney Kaufman, wala naman daw smoking gun. Diba? There is no smoking gun to speak of, and parang the prosecution is merely relying on media excerpts and speeches from elections, from pronouncements as president.
Well, technically yung threshold po dito, no? Kasi tatlong level of threshold po yung ginagamit sa International Criminal Court, no, sa mga proceedings nila. For purposes of warrant, yung threshold na required is reasonable grounds to believe that the crimes were committed. And then yung for purposes of confirmation of charges, it's a higher threshold, so substantial grounds to believe na. And then pagdating na kung if ever this will go to a full trial, then magiging proof beyond reasonable doubt na po yun, yung hinahanapin doon. But at this particular stage, substantial grounds to believe lang po. So as long as the prosecution is able to establish, parang na-plausible yung case nila, na, but yung, of course, yung actual presentation of the witnesses for them to establish na each and every evidence, each and every argument na masusuportahan nila with witnesses, with proper evidence, that will be during the trial, if ever it goes to trial.
Well, interesting you mentioned so substantial grounds. No? But with regards to an actual direct order na patayin mo yan versus merely rhetoric, ano ang substantial ground? What is a substantial ground?
Yung substantial ground po doon, no, the way the case is being built on the part of the prosecution, yung what they're trying to establish here, insofar as the link, no, kasi you're asking about the link, no, kasi you're saying na wala naman talagang direct order, no,
Yes.
parang ganun yun, no. So Nicholas Kaufman is parang he's attacking the question about the issue about the link, yung direct link. Yung tinatawag natin doon, nexus. Ano ba yung direct link doon? No? So like for example, a particular statement, has it resulted in a killing? So sinasabi ni Kaufman, walang link doon. Kung if we will examine each and every case individually, each and every killing individually, we cannot link it to a particular statement or action ni former President Duterte. Yun yung argument ni Nicholas Kaufman. Pero sinasabi naman ng prosecution dito, taken as a whole, sinasabi nila, this was done as a matter of policy. And they're saying na yung Davao model na si former President Duterte daw yung architect, author nun, siyang gumawa nun. And then parang in-apply niya on a nationwide na scale, no? And then so sinasabi nila, it was implemented as a matter of policy, parang ganon. So what they're trying to build here is they're saying na parang taken as a whole, no, parang yung multiplicity of killings, it was a product of the implementation of a particular policy. So sinasabi nila, because of that, so parang hindi na talaga individual dito. Yung parang mga general statements niya, and then they were implemented as a matter of policy. So parang they're trying to establish parang cumulative evidence to establish a particular fact. Yung ginagawa naman ni Nicholas Kaufman is to attack it parang individually.
Okay.
Parang parang doctor siya na talagang okay, let's look into the evidence one by one, parang gano'n. No? So it's a different approach.
Okay.
So ultimately titingnan natin kung which will ultimately turn to be more convincing sa mga judges.
So kumbaga, attorney, baka yung smoking gun na hinahanap natin, ma-expect natin yan if it goes to trial.
Technically po, hindi po kasi supposedly walang surprises during the trial. What they have laid down right now is tinatawag po natin na parang summary evidence. Parang they're just giving us a bird's eye view na if this goes to trial, ito yung mga evidence namin, ito yung i-present namin. And then what we expect during the trial is parang in-depth presentation na lang. Like for example, in this particular argument, sino yung witness to establish this particular. So may ipipresent yung mga witness. Now to prove talaga na each and every argument talagang may supporting witness or may supporting evidence na mapapakita sila to establish every fact na na-allege nila during the confirmation of charges hearing. But insofar surprises na may possibility ba na biglang may new evidence na lalabas, I don't think so. Because requirement po kasi sa proceedings na ilatag nila yung evidence nila lahat. Although of course they can conduct a further investigation, mga ganon. But normally, the further investigation, gathering lang po yan ng mga additional witnesses to establish the same facts na na-present na nila for purposes of confirmation of charges.
So pero bawal ang mag-introduce ng new evidence if it proves to be critical?
Hindi naman po. Kasi may isang scenario dito, no? Yung possible scenario kasi po, either the court will confirm the charges and then it goes to trial, or it will decline the charges and then technically dismiss na yung case, or it can adjourn and then it can require the prosecution to present additional evidence. Pwede rin po yun.
So yun ang mga abangan natin in the next 60 days. No? Pero I'd like to ask you also about yung sinasabi ni Atty. Kaufman that the prosecution daw failed to prove that there's a widespread systematic attack on a civilian population. Mukhang mali daw ang charge. Pag murder, baka pwedeng pag-usapan mas madali. Pero widespread attack on a civilian population, parang ginawa daw nila Mussolini, nila Hitler, mali daw, sabi ni Kaufman.
What he's trying to establish is yung distinction between an ordinary domestic crime of murder and murder as a crime against humanity. So sinasabi niya, kung killings lang to, ng mga isolated lang, parang domestic jurisdiction lang, no, di ba? But when you go to the International Criminal Court, it's no longer just ordinary murder, yung kanilang jurisdiction. Yung jurisdiction nila is dapat crime against humanity of murder. So when you say crime against humanity of murder, may further requirement yun. May tinatawag na contextual element. Okay. Yung contextual element doon, hindi lang murder. Yung murder must have been committed in the context of a widespread and a systematic attack against a civilian population. So yung pinaka-importanting element doon, the widespread and systematic attack against a civilian population. And all the murders were committed as in the context of that particular incident. So yun yung kailangan, so the prosecution was trying to establish na widespread ito, systematic ito, ganon, di ba? And then on the part of Nicholas Kaufman naman, sinasabi niya, walang, these are all isolated, hindi ito actually widespread. And then, it was not really directed against the civilian population as such. Kasi yung requirements sa Rome Statute is, the target is the civilian population as such. Meaning say, tinarget mo yung civilian population mismo. Yun yung requirement ng Rome Statute. So, yun yung parang nakita ni Nicholas Kaufman na siguro strong argument to. So, I will attack the prosecution's argument on this basis na yung target dito were actually the criminals, not really the civilian population.
So in other words, ang sinasabi ng prosecution, in this case, the civilian population could be, although ang intent was the criminals initially by this plan, pero the civilian population could pertain to the criminals and also the innocents within the context of this drug war. Parang yun ang tinatry establish ng prosecution.
Opo.
All right. Now, I'd like to understand something, Attorney, because what's happening also right now is yung detention hearing, no? We've been hearing a lot about that these last few days. Ano bang importance itong detention hearing and the appearance of the former president or non-appearance thereof?
Yung detention hearing po, kasi po yung, for example, yung whether the former president should continue to be detained, no? Subject to review po yon on a regular basis, normally once a year. So, nire-review po yun yung condition niya, and then kung talagang kailangan talaga siya na under detention during the continuation of the proceedings, mga ganon. So, it's subject to review. Kaya nga po yung mga interim release and everything, wala pong final judge decision yon, di ba? At any time, kung may mga new circumstances that changes yung, like for example, medical condition and everything, and then may mga changes sa political climate or atmosphere in the Philippines, pwede pong i-take up ng International Criminal Court ulit yung question about whether or not to give him interim release, no? Now, with respect naman sa appearance niya, I just have to explain na at this stage of the proceedings, yung appearance niya is not really that mandatory. So it's a matter of right na pwede niya pong i-waive, and in fact, na-waive niya, no? But if this goes to trial, assuming it goes to trial, under Article 63 ng Rome Statute, his presence will become mandatory. Yun yung by default, his presence will be mandatory during the hearing.
Ayun, thank you for clarifying that and your time. Attorney Ralph Sarmiento, Vice Chancellor for Administration at the University of St. Salle, Bacolod. Hope to have you back on the show, sir.
Thank you po.